Negligent driving in the first degree in Washington state. Are you charged with this crime? Are you just interested in what it is? Well, if so, this is the video for you. My name is Lance Fryrear, and I'm a defense attorney. I have a law firm in Lynnwood. We've been defending people charged with crimes for more than 20 years. Negligent driving in the first degree is a really complicated statute. It's so complicated, this is the first video I've done with my glasses on so I could read the statute. And so in this video, I'm going to cover what is negligent driving in the first degree, what's the definition. Two, what are some situations that we could see this charged and how does it differ from DUI? And three, and most importantly, how do we defend the charge of negligent driving in the first degree? So if you find this video useful, please like it. Please wait until the end and subscribe. It helps me get the information out there. And now we're going to move directly into the meat of this video. So number one, what is negligent driving in the first degree? Well, it's a crime. It's a traffic offense, and it's what we call a simple misdemeanor. It means the maximum penalty is 90 days in jail and a $1,000 fine. And in and of itself, negligent driving in the first degree doesn't carry a license suspension if you're convicted of it, unlike some other types of charges. So how is negligent driving defined in the first degree? I'm going to pull up my computer here. Basically, it says RCW 46.61.5249. A person is guilty of negligent driving in the first degree if he or she operates a motor vehicle in a manner that is both negligent and endangers or is likely to endanger any person or property and exhibits the effects of having consumed liquor or marijuana or any drug, or exhibits the effects of having inhaled or ingested any chemical, whether or not a legal substance for its intoxicating or hallucinatory effects. That's a mouthful. So basically think about it this way. So that's the legal definition. You have to drive in a manner that's negligent, which means less than perfect, right? It could be speeding, it could be swerving. It's not expired tags. You have to both be negligent and likely to endanger a person or property. So, were you likely to run into something? Were you likely to endanger someone by your driving? And you have to look like you've been drinking or using marijuana or using a drug. Exhibit the effects, okay? So, boy, that's a mouthful. So what does it mean? Basically, you got pulled over and you've been using alcohol or drugs, but they don't think you're drunk and your driving wasn't perfect. So instead of citing you with DUI, they cite you with negligent driving in the first degree. And so for us defense attorneys, we're pretty happy if we only see a negligent driving first degree charge to start, but still it's not a fun thing to deal with. So number two, what are some common situations that we see neg driving first degree charged? Well, the most common situation is the police just didn't fully investigate the DUI. The most common situation is, for whatever reason, it was late, or there's some complications in the case, a breath testing device wasn't available. Something happens in the favor of the defendant, and the officers go, well, we don't want to get a blood draw. We're not going to do all this work. It's not that bad. We're going to cite you neg driving in the first degree. So that can happen. Another time it could happen is clearly the person isn't drunk, but they smell of alcohol. They had some terrible driving. They crashed their car or they swerved really badly and they smell of alcohol. The officer gives you a portable breath test. You blow a .02 or something, and so they cite you neg driving first degree. That'd be another common situation where we see it. Third thing we want to cover are what are some defenses. So I wasn't even aware of this defense until I'm making this video because this is a newer part of the law. I see one written here. It's an affirmative defense to negligent driving in the first degree by exhibiting effects of consuming a drug if the defendant has a valid prescription for the drug and they've been using the prescription according to directions and warnings. So if you get cited for driving on your pain medication for neg driving first degree, if we can prove that you used it by a prescription and according to the label directions, then that might be a defense. Again, I haven't seen that one before, but it's written here into the law. How do we normally defend neg driving first degree? Well, normally we say, well, the driving wasn't negligent. Speeding isn't negligent, it's normal. Swerving isn't that negligent, it's normal. Or we didn't exhibit the effects of consuming anything. We didn't smell like alcohol. We didn't admit to drinking. Those would be common ways to defend neg driving first degree. But mainly what we do is we say, hey, client, hey, defendant, go get an alcohol and drug evaluation. Show the prosecutor you don't have a problem with alcohol and drugs. Do whatever gets recommended, usually an 8-hour class, maybe a 2-hour DUI victims panel. Let's try to get a result that keeps you out of jail, keeps you with your license, keeps you from having SR22 high-risk insurance. So if you have this type of problem, feel free to give my office a call. Again, my name's Lance Fryrear, the owner of the law offices of Lance Fryrear. We've been defending these types of crimes for more than 20 years. Or if you just want information and you find this useful, please like the video, please subscribe. It gets my message out there more, helps more people. If you have a problem, give us a call. We'll do what we can to help, and we'll be there for you. Thank you.